Great time to bring in my guest, Lara Yeretsian. I said it so many times to myself, Lara, and then I just blew it. And Matthew Barhoma, both with me here. First time on the program with me, so I apologize. So let's jump into what we just saw there with this. The first witness, direct and cross, split by 14 months. Let me ask you, Lara, how would you approach this witness, understanding the challenge of this kind of time lapse?
Well, I mean, the defense attorney is doing a great job here. He despite the time lapse, he's zooming in and he's really focusing on the investigation itself. And basically, he's trying to show that this was a shoddy investigation. They didn't do what they were supposed to do, which is, number one, to maintain and preserve the crime scene. And for him, in his mind, and he's trying to get the witness to say it, the crime scene is not limited to the house itself. The crime scene is a little broader in his mind. It actually includes the back of the house and the hilly area, because imagine if somebody made a forced entry, they might have left something outside in the bushes in the hilly area, and that's an area that sounded like was never secured. And his job is basically to poke holes in the prosecution theory, and if he can show that they didn't do a good investigation, this was a shoddy investigation, it's a huge win and a great point for the defense. And I think he's doing a fantastic job.
So, Lara, let me ask, as to Matthew's point there about the officer doing the investigation. This guy was like a patrol officer. You know, he's not going in there with CSI-type gear. But I think the defense made points in suggesting that, hey, there was some physical evidence. From your perspective, officer, you didn't see it followed up on. How do you take that testimony?
Again, like I said earlier, the defense did a great job. I mean, this officer is the first one there. He's the one who finds the body. And he's got 30 years of experience. If rookies are being trained on how to maintain and firm evidence and secure an area, then an officer who's been around for 30 years and has got that, well, at that time, he probably didn't have as many years of experience, but he had enough experience to know to secure the scene, and securing the scene is crucial for any case, not just murder case, but especially in a murder investigation. So, I think they did a good job showing that there was some shoddy investigation here. The right things were not done. I mean, there was some evidence with the phone wire that was not connected, and there may have been some DNA or maybe fingerprint evidence there. There was also the chips, whether it was wood chips or paint chips from a door. It seemed like an internal door. Maybe some force may have been used, and again, these weren't preserved. No one bothered to check in the hilly area. There may have been some evidence left there. No one secured the area. Those are major issues, and these are issues that are going to come up, and these are going to be part of the closing argument by the defense, saying they didn't do what they were supposed to do, so we can't really, we didn't have everything. And for that reason, we can't rely on this theory by the prosecution that it was our client that did it. It could have been anyone else. They didn't do their proper investigation, and hence you can't rely on.
Let me start with you, Lara. I mean, this is gruesome but critical stuff. What have we learned just from his small amount of testimony so far today?
Basically, we've learned that he's got a stellar background. His CV is very impressive. I mean, he was the chief and he was overseeing a lot of people. So bottom line, that gives him a lot of credibility. We know that whoever did the autopsy, the doctor who did the autopsy, is no longer or has retired since. So he, as is usually done, the supervisor at the time was approached by the DA, and now he's testifying for the government. All we've got until now is that we've got an entry wound to the back of the head, like you said, 2 inches, star-shaped, and we know that the bullet obviously was lodged within the head. There's no other issues that he has mentioned as far as any other reasons or causes for the death other than the gunshot wound to the head, as far as this witness is concerned.
Lara, do you think that when we hear about this story that the defense is telling that, hey, Robert Durst was scared, he ran, the Westchester County DA was after him, I don't know if you have to have Aspergers to react that way, do you?
Not necessarily, but if you notice, he put it very, very strategically, and he did it the right way. He said he was fearful of an ambitious prosecutor, not fearful because he'd done something wrong, but quite the opposite. He was fearful of an ambitious prosecutor. And I think this idea that he's autistic, what they're going to try to say is he may not react the way most people will. And yes, he's a little weird. And that's why he's reacting sometimes this way. He can't read body language. He can't read other facial expressions and cues. And yes, sometimes because of that, he's going to react differently. Maybe it'll be a little more dramatic or less dramatic than others. And let's not, it does, as I said before, it does draw some sympathy, but it also explains some of the things that's going to come up later during this trial, that maybe he was sometimes mean and not so understanding towards some people. And that's, again, they're going to go back and fall back on this autism and hope that it helps them.
Yeah, so the persona is cold and detached, and that's not him, that's the Aspergers. So I don't know if it's sympathetic or just explanatory, but I can see how they can use it however they can use it to help the defense. Lara, let me ask you about that. Is the goal, and you do criminal defense, is the goal in part just to give the jury something else to latch on to?
Probably in part, but that's probably not the only. I mean, number one, it does get their sympathy, but number two, it also explains why he's reacting a certain way. Think about it. An individual who cannot really read body language, facial expressions, and cues is not going to react to things the way you and I are going to react. And you know that this prosecution is going to make a big deal about what he's doing and how he does things and his reactions and notes and this and that. So that's going to be, yes, an explanation for why he's doing these things. Remember, again, when you've got circumstantial evidence and you've got two reasonable explanations for that circumstantial evidence, then the jury is going to be instructed to go with the one explanation, to go with the reasonable explanation that points towards innocence. And I think that's going to be part of that. This defense is doing a lot of that. We saw some of that also with the list that they had provided, the list of people who Susan Berman had borrowed money from, and also the check where you could see a writing in the back of the check saying, "I love you, thank you, and I'm going to pay you back." Guess what? Someone who's extorting you, and when you're paying somebody hush money, that's not the kind of note you get in the back of the check. They're not thanking you and promising to repay you, right? So they're giving a reasonable explanation. They're taking the strength and they're weakening the prosecution argument.
Yeah, that's a good point. You don't put a little love note on the back of, if it's hush money. So how do you use a murder somebody was acquitted for in this case?
Here in this case, they're using it to prove the motive. And it's interesting. It's a good point, and I'm sure the defense tried to fight it. They probably didn't want any of this to come in. I mean, the man's been acquitted, but in this case, clearly the court has allowed it for them to show what his motive is and to make the connection. Basically, argue that he killed his wife, and look, he did this again. He shot this man. He's done this before, and he's doing it again with Susan Berman. And they're going to connect all of these dots and have their story. Clearly, the judge is allowing it, and we're past the point of how did he get it in there. It's there, and we're going to have to deal with it. I mean, they're literally trying 3 murder cases in one. I mean, that's a huge, huge issue for the prosecution. It's tough enough to try 1 murder case. To have to try 2 other murder cases within one just to get a point across, and your theme and your prosecution view across is a big.
If you're the prosecution, $25,000 paid twice to Susan Berman over a pretty short period of time, guys, was hush money. If you're the defense, hey, Durst is just free with his money. Look at all these people he's paid money to. He was a good guy. It was a friend. It was a gesture. She needed help. He helped her. Lara, what do you think?
I think it's a great argument. Clearly, when the evidence can point, the same evidence is circumstantial, if it can point towards innocence and can also point towards guilt, and they're both reasonable explanations, the jury is going to have to take the one that leads towards innocence. That's what the law in California says about circumstantial evidence. And I think the defense, if they can prove that, if that list is true, I think it's a strong point, and I think it takes the and the strength out of that prosecution, that particular argument by the prosecution.
Yeah, I think it's really good. And it is going to be fascinating to see how that evidence comes in.